All right, we're going to go on the record and cause number 2026 CR 007561, State versus Amanda Sabrina Morehouse. Can I have parties approach and announce for the record?
Yes, yes. Very great. See. Warren Wolf, Ms. Morehouse.
And probation, this is an application. Hello, good morning.
Good morning.
Are you Ms. Morehouse?
Yes, ma'am, I am.
Welcome back to the courtroom. We are kicking things off with Judge Boyd, a no-nonsense Texas judge who does not play games. Today's docket is packed: drugs, theft, firearms, and even a protective order case. First up, Amanda Morehouse, facing a possession charge that could put her away for 3 years. But watch closely. The judge is about to lay down the law, and Amanda has a choice to make.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Morehouse, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am, I'm sure.
Did you review the true bill of indictment with your attorney?
You're holding right there.
It's the document that tells you what you're charged with.
Yes, ma'am, I did review it, but I did have a quick, and
Yes.
then I talked to them. They did not find that on my person in front of the video, and that's what I had to explain to them.
All right, so let me explain something to you. Number one, if you want a jury trial, I will give you your jury trial. Number two, what ends up happening when you enter a plea, the state usually doesn't present any witnesses. They just present police reports. I will review the police report. And then what I can tell you, if from reviewing the police report, if it doesn't establish your guilt beyond a reasonable doubt, then I'm going to find you not guilty. I'm going to find that the state didn't prove its case. However, sometimes people don't understand with possessions of drugs and when you're being accused of possession, hypothetically, because I don't know anything about your case yet because I haven't read anything. But if you're in a vehicle, I'm just telling you hypothetically, if you're in a vehicle, it's you and it's 3 other people and there are drugs in the vehicle, everybody can be charged with possession of the drugs. What it will depend on is it within your reach? Because it's just all about care, custody, and control. If you're riding on a bicycle and the police pull you over and there's something in a backpack on a bicycle and you were riding that bicycle, you're in possession. Now, if you're saying, I didn't know these drugs were in this backpack, this is not my backpack, that's something for a jury trial. You understand? So if you want a trial, I will give you a trial. If you do not want a trial, then we'll continue with the plea. I'm going to read everything. I'm going to explain to you your rights, and then I'll make a decision on whether or not the state has presented sufficient evidence to find you guilty beyond a reasonable doubt. You understand?
Yes, ma'am.
Do you have any questions about anything?
No, ma'am.
Okay.
Thank you.
You're welcome. Oh, you're welcome. Please ask questions about anything that we're going on here today, because this is the most important thing in your life right now, okay?
Mhm.
All right, so the indictment tells you what you're charged with. Did you have a chance to review that with your attorney?
Yes, sir.
All right, did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of this indictment?
Yes.
State, are you proceeding on the indictment as she has received it?
Yes, that's as she was.
Ms. Morehouse, did you review the court admonishments? It's this
No,
document that tells you what your rights are.
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
All right, I'm going to go over your rights with you. If there's something you don't understand, let me know.
Thank you.
You're welcome. Okay, so you're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have an agreement with the state, I don't have to follow your agreement. If I don't follow your agreement and give you more than what you've agreed to, the fact that you entered a plea will not be used against you. You can withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent. By entering this plea, the state is not going to call any witnesses. So there's nobody for you to cross-examine, and you're giving up all of these rights, the right to trial, the right to remain silent. Do you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
yes,
Ms. Morehouse, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than your plea bargain agreement?
no,
Are you satisfied with the way you've been represented?
no. To the best of my ability.
All right,
I mean, to the best of the case ability.
okay. Do you understand if you're not a US citizen, you will be deported, denied naturalization and reentry? Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,000 fine that's to be probated. So what that means is if you successfully complete your probation, you don't have to pay the $1,000. If you are unsuccessful in the completion of your probation, you may have to pay the $1,000. Do you understand?
Yes, ma'am.
And the court is and the state is recommending community supervision. Do you understand that as your plea?
Yes, ma'am.
State defense?
That is the plea, Judge.
it is, Judge. There's also this, Morehouse wanted to apply for deferred, but that is not, that's outside the agreement.
Okay, there are no boxes checked for deferred.
Judge, the state did that for community supervision.
I had been in
Just-
trouble.
just wait,
before
just wait.
16.
All right, so here's the thing. Your agreement is not on an application for deferred adjudication. Now, if the state wishes to change their agreement and let you apply for deferred adjudication but be opposed to it, they can do that. But according to this plea bargain agreement, there is no application for deferred adjudication. Do you understand?
We discussed
We discussed it.
that to permit her to apply, that you would let the judge decide that, but you were going to agree to the probation.
We were gonna agree to community supervision.
Right.
Just please step back for a moment.
Sure. All right, y'all step back. Destiny Jackson.
You get my glasses fixed, Judge. New prescription time.
Well, they keep wanting to do a line for me, and I'm absolutely not, because I only need my glasses for distance, not for reading. And so the ophthalmologist said, oh, when you are tired of taking your glasses on and off, you'll get the line. I'm like, I will never be tired of doing that, so it won't be happening. All right. Good morning. All right, so what do you have in your mouth?
Cough drop.
Oh, cough drop? Okay, I'll allow it. All right, today's plea deadline date.
We've conferred, we don't have an agreement right now, Judge. We just get it on a trial route.
All right, Ms. Ferguson. On this case, if you set this for August 17th for jury trial.
Yes,
All right, your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you'll have to plead open to the court. If I could get an acknowledgement of discovery, please.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Ready.
All right, thank you. All right, we are back on the record. In 2026 CR 007561, State versus Amanda Morehouse. Could parties re-announce for the record, please?
Yes, Judge. Brandon Prayer for the state.
Warren Wolf or Amanda.
All right, so with regards to the plea bargain agreement, there is no application for deferred adjudication in the plea bargain agreement. Is that correct?
Correct.
Right. Judge, the agreement was we were going to agree on probation, but we
Permit
were
her.
going to apply for deferred and the state would be opposed to it.
All right, that's not in your plea paperwork.
Well, let's amend this. I think we've got this squared away,
Okay.
Judge.
All right, so with regards to your plea bargain agreement, you're applying for deferred adjudication. The state is opposed to your deferred adjudication. Do you understand?
They're not agreed to.
when the state doesn't want to agree, so that also depends on,
I'm sorry, you're gonna have to speak up.
that also depends on you. You
Yes,
decide.
I'll make the decision.
And I-
Do you understand that as your plea?
Yes, ma'am.
Now,
I
let me
have been in trouble.
All right, let me explain to you about deferred adjudication.
All right, pause, because this is a huge legal moment. Judge Boyd is breaking down the difference between regular probation and deferred adjudication. In plain English, with regular probation, if you mess up, you get the original sentence, here 3 years. But with deferred, if you violate, the judge can throw the entire book at you, up to 10 years in prison. Amanda is begging for deferred because she wants to keep this off her record, but she is literally gambling with 7 extra years behind bars.
With a deferred adjudication, if I were to grant it, if for any reason your deferred adjudication were revoked, the court could grant the motion and sentence you up to 10 years in the prison. Do you understand?
Yes, I do.
With regular probation, for example, according to this plea, the state is recommending community supervision and they're asking that your punishment be assessed at 3 years in prison. So under that scenario, if I were to give you community supervision or regular probation, if for any reason you were revoked, the court could only sentence you up to 3 years. With the deferred, if you're revoked, you could be sentenced up to 10 years. Do you understand?
I do understand.
And with a deferred adjudication, if you successfully complete it, it will be on your record, but it won't show up as a conviction. Do you understand?
That's what I want.
All right. So does everybody understand that to be the plea?
That's what I'm saying, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years, 100 hours of community service restitution, that's working somewhere for free, the MRT, regular UAs, and a mental health caseload. Did you understand those were recommendations from the state and I do not have to follow those recommendations?
Yes, ma'am. I do understand.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Judge, we offered you state exhibit number 1, including all of its attachments.
No objection.
All right. State before you leave, is there a reason you're objecting to deferred?
Judge, it looks like the defendant was already on deferred for theft property 50 to 500. He received deferred adjudication on that. It was extended a couple of times. That ultimately ended in 20 days in the Berry County Jail. Further, she does have a conviction for resisting arrest.
Okay, all right, thank you.
Of course, Judge.
All right, Ms. Morehouse, did you review the waiver and stipulations with your attorney?
Yes, ma'am, but I do.
Just wait, you can just listen to what the judge says.
All right. Again, do you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Do you understand?
Yes, ma'am.
Do you understand that today the state is presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Do you wish to proceed with sentencing? Or are you asking for a PSI?
We can proceed.
All right, so first things first. 1, I reviewed everything. The evidence is sufficient. So the state has proved their case beyond a reasonable doubt, according to the stipulations. Now, with regards to her criminal history, the state has recited her criminal history. Is that the correct criminal history?
I was not representing her on those matters. I've discussed some issues about her past. I don't know if she understood at the time what was going on.
For what, the cases that her criminal history?
Yes. And I'm not sure of her mental status at those times. As far as today is concerned, she understands what's going on. And she would like to talk to the court about her history and why she why she's asking for.
Sure.
I just heard the state say something about theft. I don't have any theft on my background. And I haven't been in the state of Texas. I've been back to state of Texas for 7 months.
Where were you before?
I was in state of North Carolina. I had a.
I'm sorry, where?
I was in the state of North Carolina for the
Oh,
last,
excuse me, everyone, please whisper.
for the last 11 years up until this year, up into the state of North Carolina with the job. So I don't know
Here's the thing.
where they come and see something like that.
So were you in Bear County on April 23rd, 2026? Because that's the date of this offense.
But it was a trespass, no trespass.
No. It was not. Let me just tell you what the facts of this case are. You were in a park. The police received calls that somebody had a lighter trying to light things in the park. That was you.
Just listen.
And then they brought you over to search you. They had a female officer to do that because they need female officers to search females. They saw you drop baggie on the ground. That's where the possession comes in.
That's what's in the report.
So that's what's in the police report. So let's start here. Why were you in the park with a lighter attempting to light the grass?
It was not, I had a cigarette in my hand. It was the cigarette that I had in my hand. When the officer got there, I had no cigarette in my hand. I had just a lighter in my hand.
Mhm.
And the female officer searched me.
Well,
But they
no, let me
were,
just tell you, the police received a phone call, and the call stated that you were attempting to light a flame in the open field using a lighter. And it's April, so I'm assuming Texas, San Antonio, it's dry. You can start a major fire. So what were you doing in a field at that time?
I was walking on the sidewalk I wasn't even in the park. I was on the sidewalk. And I had sat down on the sidewalk on the curb, and I sat there and I had a cigarette in my hand.
No, that's not what this says. They say you were in the field.
Well, we looked at the video and you were
I
not
was
on.
not in the field of the park. I was on the sidewalk. That's what
Oh,
they.
is there a video?
Yes, and we've looked at it. You were not on the sidewalk.
I was on the sidewalk.
When they approached you.
Yes, I was. I was on the sidewalk.
After that, after you left
I
the
was on the
sidewalk,
sidewalk.
you were back in the middle of it.
I promise to God, I was on the sidewalk.
Oh, you know what? If you want me to view the video, I'll view the video.
I was on the sidewalk when
All right,
they went, the officer.
State. Sure. Defense, the state is going to be offering the video into evidence as state exhibit number 1. Any objections?
Judge, they tendered it to me. I just did.
I'm sorry, Mr. Prater,
Yes, sir.
because because the stipulations are state exhibit 1 and attachments, do you want to make that state exhibit A?
That's perfectly fine.
All right, so the state is going to offer state exhibit A into evidence. Any objection?
No.
And I will review it. Let's play it. Here's the thing. Sometimes, well, not sometimes, you really should listen to your attorney, okay? All right, while the state is pulling that, have you ever had any type of mental health diagnosis? You've never been prescribed any type of medications? I need yes or no.
Not for mental health, no.
Oh, what, have
I
you
have
ever?
scoliosis.
Okay. Do you have any family here in San Antonio, any support system?
Not here in San Antonio. All my family's up north.
All your family is where?
Up north.
Okay.
The public shakes to the court judge.
Yes. Granted. And this is State's Exhibit A, correct?
Yes.
All right, thank you. All right.
Ouch. The video evidence just destroyed Amanda's entire defense. She swore she was on the sidewalk, but Judge Boyd watched the footage and confirmed she was in the park trying to light fires during a dry Texas April. That is not just a bad look. It is reckless. And the judge just gave her a golden ticket to withdraw her plea and demand a trial. But here is the problem. If she takes the stand and lies again under oath, that is perjury.
So, Miss Morehouse, from watching the video, you're not on the sidewalk, you're in the park. You're not supposed to be in there. And the problem is, during these months, lighting fires on grass that cause a whole host of problems. You can't do that. So I'm telling you what the stipulated evidence is. I'm telling you what I viewed in the video. If you want to withdraw your plea, you're more than welcome to withdraw your plea. We'll send you back over to the Bear County Jail, have you dressed, and we can start a jury trial today. Do you understand? You need to speak up.
Yes, ma'am.
All right. So how often have you been using before you were taken into custody?
I haven't been using, and
All right. So this is what I'm going to tell you. I'm going to grant your application. If you end up testing positive, that's a violation of your probation and a warrant is going to be issued for your arrest. Do you understand? So I go back to my question. How often before you were placed in custody were you using drugs?
You gotta speak out.
I wasn't using for the officer.
All right. Do you have any children?
They're adults.
Do you have any grandchildren?
Yeah,
I'm sorry.
yes, ma'am.
What are their ages?
4 and 5.
And do they live in San Antonio?
They don't.
When's the last time you had employment?
3 months ago,
Doing what?
TJ Maxx Warehouse.
All right, this is what the court is going to do. The court is going to find you guilty. The court will sentence you to $1,000 fine that will be probated. Regular reporting by Zoom or in person. Excuse me, no hugging up in the courtroom. Save that for outside on your own time. Regular reporting by Zoom or in person. Random UAs. Monthly. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Field visits 1 time per month for 4 months. TAP evaluation out of custody. 100 hours of community service restitution. I'm going to order the MR. You can do a MIC evaluation. And that can be done out of custody. And the 100 hours of community service restitution, I'm going to order the MRT. Once that's completed, the community service hours will be deemed satisfied. The court will sentence you to 3 years in prison, suspended and probated for 4 years. And there is to be no residing in households with minors. No unsupervised contact with minors. And there's to be no contact with Palo Alto Park. Probation, is there anything else?
No, ma'am, I believe you've got it all.
Thank you. Did you review the document entitled Trial Court Certification of, she hasn't signed this.
What you do?
No, she signed in my spot.
Yes.
That's okay.
Well, she has aspirations.
Uh-huh.
You missed this one.
All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Santiago Hernandez.
May we approach, Judge?
Yes. All right. Today is plea deadline date.
Judge, we've accepted the state offered pretrial diversion today, and we're going to get that application in today.
All right, I need a PTD date.
And to be fair to the state, I presented them information that changed their offer, so it's not that they waited, it was me.
All right, thank you.
I can do the 31st.
All right, once you sign the reset form, you're excused. Make sure you follow through on everything that's asked of you. Do you understand? Is he a
Judge,
Spanish
yes.
speaker?
Yes,
All right,
I
we
know.
need an
I
interpreter.
know. That's my fault, Judge. I'm
Thank
sorry.
you.
Lucia.
Call for an interpreter, please. Nicholas Morris.
Can we approach, Judge?
Yes. Spanish speaker?
No, no.
Swahili.
Nicholas is talented. He might, but he does know English very well.
Okay, awesome.
Morning, Eric.
Good morning. How are you doing today?
Good.
All right. So what is happening? Today is supposed to be disposition day.
Judge, we have accepted an offer that requires us to plea in a misdemeanor court that is closed today. He's set on the 4th there.
Okay,
And that will resolve everything here. The case here will be completely disposed of without a plea.
all right. So you're saying he's set on August 4th?
Yes, Judge.
All right. Let me see something. All right, Norman, recall this for August 4th
Thank you, Judge.
and go to misdemeanor court first.
Over your neighbors.
You too.
May we be excused once we've signed our forms, Judge?
Yes.
Thank you.
All right, who's next?
On page 6, fifth one down, Pamela Travieso. Pamela.
Okay. Yeah,
So she's got 3 cases that are at large that are coming down the pike. We're gonna try to work out a deal where all of them are gonna be disposed of. I've already spoken to the prosecutor and they're amended to that. But we're still waiting to see on the 3 cases. So we're needing another reset and orders because all these cases will be disposed of together.
so how much time do y'all need?
At the at large, I'm thinking 30 days.
All right, Ms. Ferguson, I need a 30-day reset. And you can just say it's for discovery. When?
Got it.
All right, August 31st. Once you sign the reset form, you're excused.
Thank you, Judge.
I thank you.
I
Good
appreciate
seeing you.
Go ahead and have a seat. I gotta take a reset.
Who's next?
I have,
First.
4, first one, Donnell Smith. She left proposed.
Janelle Smith? It's like I just saw you. Yeah, your client was back there hugged up with somebody. Okay, so on this case, we were here for discovery, and I know you were recently appointed.
I was appointed at the last setting.
Yes.
And I just got access to discovery within the past 5 days. I've got to get it all downloaded, make sure I have everything, and then go through it and sit with my client. All right, so.
All right, so
I need some time.
we are going to recall it for 45 days. So that'll give your attorney a chance to have discovery.
Yes, ma'am.
And are you employed?
Yes, ma'am.
Right, so you can appear by Zoom because it's a discovery date and your attorney will give you the Zoom link. But when you appear by Zoom, you have to be dressed appropriately, okay?
Yes, ma'am.
And not hugged up. All right, Ms. Ferguson, I need a 45-day reset.
September 14th.
All right, so we'll be back on September 14th. Once you sign the reset form, you're excused.
The interpreter's here for us, Jan.
All right, if they'll come up, please.
Usually writes it down.
And what is your client's name? I'm trying to find him on the docket.
Santiago
Santiago?
Hernandez.
Okay,
It's on page 2, Judge.
thank you. Hello. Okay, now I know that you don't say, one thing I do know. I know that you don't say hello in Spanish. That's not Spanish, is it?
It's not Spanish.
Deputy Laura? Is hello Spanish?
No.
You gotta use the interpreter. Or either we won't use the interpreter. Do you need the interpreter?
Yes,
Okay. That's Spanish.
it's business partner.
All right, so you're gonna come back on August 31st. My understanding there's an agreement for a pretrial diversion. You need to make sure that you follow through on whatever is in the contract. And if you have a question about what's in the contract, you need to speak to your attorney. Do you understand?
Yes.
All right, once you sign the reset form, you're excused.
Okay.
All right.
Yeah.
Good night.
Thank you, Judge.
Thank you. All right, who's next?
Page 4, fourth from the bottom, Matthew Barber.
Matthew Barber. Yes. All right, how are you doing?
Pretty good.
We're dressing appropriately for court.
I've tried to commit them.
So today is your plea deadline date.
Okay, I thought it was discovery.
Mm-mm. Because last time y'all were here, an offer was tendered. But so, do y'all need more time?
We do, Your Honor. I'm sorry, I've been
No
so
problem.
busy.
Okay,
Thank you.
all right. This will be your final plea deadline date. Norma, recall this in 30 days for final plea deadline date.
Okay,
All right, so it's August 31st. At that time, you'll need to let me know whether or not you all have reached an agreement. If you have not, your next court date is going to be a jury trial date. You understand?
all right.
And you need to make sure you're on time for court. It's at 9 a.m.
Thank
Okay.
you, Your Honor.
All right, thank you.
Appreciate it.
You're
Bye-bye.
welcome. All right, Kit Kilpatrick. Hi, where's Kit Kilpatrick?
She is in the Gillespie County calaboose.
Oh, okay.
She was here, Judge, she was here the last day Mr. Smith was here.
Yeah.
And she had an MTR or motion to enter adjudication in Gillespie County and a new case up there.
Yes.
I've been in touch with her attorney. They have made an offer, deferred on the new case. They're going to reduce it with deferred on, keep her on deferred on the other case, on their MTR case. And they want her to go to safety.
Okay.
The rec here was for SATF, but I talked to my client yesterday. She's willing to go to safety, wants to go. And so,
Probation, can you come forward? Stay on Kit Kilpatrick. Can you all come forward, please?
yes, it's kind of a logistics question right now. Do we want to let her go ahead and get sentenced up there?
Yes. So on this case, she has a case out of Gillespie and we released her so she can go to Gillespie. He says on the MTR in Gillespie, they are denying the motion and alternate amending for safety. Here, probation's recommendation was SATF. So are you all okay with withdrawing this motion and just alternating amending conditions for safety? Because the new number one is a possession case out of Gillespie County. So she has 2 violations.
And Judge, the reasoning for recommending SATF is that we start at the lowest modality.
Mhm.
And then we have some place to go after that. Whereas if we start with safety, it's difficult if they relapse to then get them into SATF and get them back through all of that. That's the only reason. But if Gillespie's, if that's the only way they're going to continue her, that's fine. Since she's living here, she can finish they can do the packet, they can do the referrals and everything, and then we can do the aftercare portion of it with our safety aftercare unit.
Judge, I would just need the order from up there then, just because she has 2 prior, she's on deferred in like multiple counties. So the only reason I'm even agreeing to this is because that's what they're saying up there, but yes, I need proof.
Okay. All right. So when do you think you'll be able to get proof of that?
They want proof, I guess, call the DA and ask her.
I'm thinking your client will enter their plea and then I can get the judge.
Oh, that's fine.
He's like, oh, I don't want.
Yeah, that's the proof you want. I'll tell them to go ahead and get it done.
Okay.
Yeah,
Okay.
fine.
All right. So y'all want to recall this in what, 2 weeks, 3 weeks?
I think it should be, I want to say that her attorney told me her next setting is in September. They may be able to expedite that, but they don't do their docket like we do with us.
All right.
Where they have dockets every day, I don't think.
September, that's a long,
And if you would like, I will email her today and find out when she can get her in court, and I'll let the court know.
all right. Norma. All right, we're gonna recall it for August 31st. And that, oh, can I have the MTR back? We'll recall it for August 31st, and that August 31st date, we'll see where we are.
Okay.
Okay,
You need me to sign anything or just, I'll make,
okay,
okay.
just be here on August 31st.
Thank you.
All right, thanks. Jay.
Yes, you're welcome. Gabriel Martinez. All right, where are we on discovery?
Judge, I believe all discovery is intended.
Well, Your Honor,
Our knowledge.
Actually, Your Honor, we filed a motion to withhold because we have not received all the discovery in this case.
All right, what discovery have you not received? If you will, well, if you'll let the
Well,
state know.
well,
I
we,
think there was some lab discovery.
actually, when I talked to the state, they said they were gonna dismiss the case if we went and did a plea and misdemeanor. That was kind of a surprise to me.
Yeah, yes, Judge, we have a plea worked out.
All right, so when are you on to take care of the misdemeanor?
Right now.
All right, go take care of the misdemeanor, then come back.
Great, thanks.
Thank you.
Thank you.
All right, thank you. On Ryan Westbrook, what is happening with that case?
Judge, and I've got paperwork with me. I haven't talked to my co-counsel here who knows more than I do, but I think he got sentenced in federal court the day before yesterday. And I brought the stuff off Pacer to give the court as well as the state. But he's still in federal custody. He's going to be in federal custody because he's got consecutive sentences over there on
so-
just a 2-count indictment. But
If you'll talk to the state, so how many months?
well,
You know, federal court is the only court where they still count months like you're a baby,
yeah.
you know, because it makes you sound so young. Oh. Yes.
He got
I'm 200 months old, you know, people are like, oh, that's not old. And then you start doing the math. You're like, whoa.
You had 27 months consecutive to count 2, but it doesn't say in here what he got on count 2. So, but I'll figure that out. And I don't think a judgment has formally been entered yet because it just happened. But if you give me a few minutes, I'll report back to the court and I'll let you know exactly what I think happened.
Robert Galvan.
Yes, yeah, that's a.
Hello, welcome back from your vacation.
Thank you, Judge. I'm glad to be back.
Yeah. So how was it?
It was great.
So was it a staycation or did
It
you
was
leave?
Port Aransas, so just a little family time. Brought the dog, brought the fiance, and that was it.
Oh, no, that's
Yeah,
awesome.
just a little chill time.
I always say it's like the song, everybody needs some time away,
There you go.
sometimes far away from each other. Yes, I love Chicago, right? All right, so where are we on this case?
Yes, Judge. So I need to look at, there's something I want to look at in the body cam footage, but other than that, I think we're ready for trial. We have gotten a plea offer.
Okay.
But it sounds like we're gonna try this one.
All right, Ms. Ferguson, how long do y'all expect this trial to last?
I would anticipate 3 days with jury selection.
All right, Ms. Ferguson, on this case, set this for a jury trial and plea deadline date in August, please. Yeah, 17th. Yeah, August 17th. They'll bring you over dressed for trial.
Okay,
All right, thank you.
we'll be here, Judge.
Thank you. Oh, if you can do an acknowledgement of discovery.
I have unavailability. I'll be in Travis County for a hearing on the 17th.
All
But
right.
I will be back on the 24th, the following Monday.
Wait a minute, you're in Travis for,
So I'm in Travis on Monday. I'm in Bastrop County Wednesday, New Orleans that weekend.
okay, New Orleans, you're not doing anything. I know.
It's our wedding in October 4th, and so I gotta do the walkthrough and final payment August 2021.
Oh, you are getting married in New Orleans?
Yeah, I am.
Okay.
I'm excited.
Well, all right, Norma, set this for August 10th. Yes. All right, see you then.
That'll work. We'll see you then.
All right, and he'll need to be brought dressed for trial. And State, if you could do an acknowledgement of discovery, please, on Galvan. Adam Vasquez.
And we approach Judge?
Yes. Court is calling 2026 CR 002624 State versus Adam Vasquez. Can I have parties announced for the record? State? Defense?
Jason Todd for Mr. Vasquez.
And are you Mr. Vasquez? Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Probation, this is an application.
Yes, thank you.
And it's an application for deferred adjudication. Mr. Vasquez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Correct, that's not.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, it appears that you're proceeding on count 2 and waiving count 1.
Yes, Your Honor.
Any objections?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it
Yes, ma'am.
and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Judge, we've discussed possible defenses and the case.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Vasquez, anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Did you? I am so sorry. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. You know what the problem is? I'm reading the stipulations at the same time as this. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is waiving count 1. They're proceeding on count 2. There's a $1,000 fine to be probated. State recommends deferred adjudication. There's to be restitution to the Bexar County Crime Lab for drug testing of $120. Did you understand that to be your plea?
Yes, ma'am.
State defense?
It is, Your Honor.
That is correct, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
There were not, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation, 100 hours community service restitution, MRT, and the DOEP course. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence.
The United States one at a time.
No objections, Your Honor.
All right, state 2 may be excused. Am I talking too fast?
Mark.
Did you review the waiver and stipulations with your attorney?
Yes,
Did you understand it and sign it in all the appropriate places?
yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court will review the same. The court will find that the evidence is sufficient, and to find you guilty, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would first of all just ask you to follow this plea. This was a mistake, and he's ready to get back to his life. Not a mistake in the sense that he didn't choose it. He realizes that his choices were a mistake. He's taking responsibility and is ready to get back. He worked very, very hard. And he's honestly just, in all of our conversations, our biggest struggle has been getting him to find time outside of work. And so, which I think is not a bad thing. I think it's a good thing that he is focusing on better things than what he was doing that evening.
All right, if you're drug tested today, what are the results going to be? And you will be drug tested today.
I mean, just whatever those CBD stuff I get from a shop, that's it.
You're not allowed to.
Oh, I wasn't sure about.
Yeah, you can't use any
No,
type of.
it won't be after this, but
Okay. So what do you do for work?
electrician man.
And do you have any children?
Correct.
Yes or no?
Yes, ma'am.
What are their ages?
There's multiple. We got 5, 9, And then 11, 12, 16. Yes,
Wait a minute. Just one second. Okay, what ages?
5, 9. 9 and 10. Ages under 12, and they're 16 for that.
So 5, 9, 10, 12, 16?
Yes.
And do they live with you?
At the moment, not currently. Get them weekly. Right now, I've been single for the past about like a year and a half, almost 2 years.
All right. And in the stipulations, they say that he had several municipal court warrants or whatever. Has that been taken care of?
I am not aware that they have been taken care of.
Sure, I know we brought it up to Ramos, talked about it.
So we're taking care of them.
All right. Because here's the thing. Municipal court, they've stopped picking people up if they have warrants in their court. So there's nothing we can do about that. But if you're out and about driving, they can arrest you. All right. Court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, restitution to the Bexar County Crime Lab of $120. And the regular UAs, you can either do regular UAs or either you can do the patch. They will tell you with the patch, it costs more. However, the patch is going to show up everything. And if you're going to be positive, then make sure that he's tested for levels and do not put the patch on him until he presents with a negative UA.
Yes, ma'am.
Proof of employment within 30 days, no employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the restitution hours will be deemed satisfied. Field visits 1 time per month for 2 months. TAP evaluation out of custody. Follow TAP results or recommendations, I should say. Probation, is there anything else?
No, ma'am.
Is there anything else you need from the court to be successful on this probation?
No, ma'am.
All right, make sure you stay in touch with probation and stop using.
Appreciate it.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
And I'm sorry, add no possession of firearms because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court, okay?
Yes.
All right, and take care of those tickets.
Appreciate it.
All right, good luck.
Thank you, Judge.
Court is calling 2026 CR 007866 State versus Nathaniel Alvarez. Can I have parties announced?
And Jonathan Alvarado for the defense.
And are you Mr. Alvarez?
Yes, ma'am, but you got my first name wrong.
Oh, Nathan? Oh, I'm so sorry. See, you need to let people know because otherwise they will say it wrong forever. So are you Nathan Alvarez? Okay. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Alvarez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, did you review the true bill of indictment with your attorney? I'm sorry, with your client?
Yeah, yes, Judge, I did, yes.
And do you understand the true bill of indictment? Counsel, do you waive the reading?
Yes, Judge, we waive.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Alvarez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with obstruction or retaliation as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe so, Judge. Yes.
Mr. Alvarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, there's a $1,000 fine to be probated. State recommends deferred adjudication. They will take in consideration 2026 CR 007869. Did you understand that to be your plea?
Yes, Your Honor.
State defense?
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
No.
Counsel, any such motion?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service, and the life skills course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, see offer receipts exhibit 1 and all attached.
No objections.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
How old are you?
This is the moment that hits different. Judge Boyd is not just laying down a sentence. She is giving this young man a reality check. He cursed at his mother, got intoxicated, and brought chaos to her property. The judge is basically saying, you are disrespecting the one person who gave you a roof over your head. And watch her face as she says it. This is personal. She is not just punishing him. She is trying to save him from himself.
19.
Why are you living? They say it's a shack. I don't know if it's a shack or if it's a guest house, but in the report, they say it's a shack. Why are you living in a shack on your mother's property, getting intoxicated and bringing, I guess, your girlfriend, whoever else it is, to get intoxicated? That is very disrespectful to your mom. Why are you doing that? Well, I mean, what do you do for a living? Do you work?
Yes, ma'am. I'm a roofer.
Did you graduate from high school? So why are you getting intoxicated and bringing random people to your mom's backyard? And did she ever agree for your girlfriend to be living in the shack?
Yes, ma'am. It's because we had it like a piece of stuff, like a little casita in the back, but we're rebuilding it.
Mm-hmm.
So now it's like we're making it to a room.
Do you know they said that you cursed at your mom doing this? Have you apologized to her?
Yes.
When's the last time you drank alcohol to intoxication, and then there was marijuana there too? When's the last time you did that?
Alcohol was that time, you know, but marijuana like a couple weeks ago.
All right. So let me just tell you, you smoking marijuana, perhaps maybe high or not, If you're on a rooftop, you could fall, and guess what? That's all on you. You understand?
Yes, sir.
Do you have any children?
No,
Are you still with this girl?
no,
And is your mother still allowing you to live there?
yes.
I just made an offer as well, Judge. In speaking to my client, when I first met him in custody, he immediately acknowledged to me that he was intoxicated when this happened, and he was remorseful for his actions, especially when it comes to how he treated the police as well as his mother. Talking to him today, as he said, he's a roofer. He works for a company his family member is also part of. He had been in school, but he's working pretty much full time now. And so he's a young man. He obviously made a really, really bad decision that day, but I think he's extremely remorseful for his actions, and he wants to show the court he's changed.
Have you apologized to your mom? All right. What I can tell you, I guess I can say this, but I don't drink. It doesn't taste good to me. But I don't know how somebody can become so intoxicated that they end up directing profanity at their mom. If your mom is not like the mom in civil, there's no excuse for that. And she will always remember that. And stop bringing random people back to the housing that your mom has so graciously given you. You understand? Don't even ask her, hey, can I bring this person to live here? You know, just random people you don't even know. And I know the other a guy who was there, I don't think the mom agreed to that. Okay, so your family needs to stop allowing the young people to drink to intoxication. That is not good. You understand?
Yes.
And I don't know what female would feel comfortable with two intoxicated guys in a room with them, and then she's intoxicated as well. That's not good. You understand?
We were, you're on country.
Sure.
We were at my cousin's and I had got home and that's when like everything happened. Cause I wasn't home.
Mhm.
And I got home all intoxicated too.
So everybody intoxicated. Was there a single person in that shack who was not intoxicated? And do you know how intoxicated you have to be for your mom to call the police? And then they had to call, the fire people out to make sure that nobody's going to die for intoxication. All right, this is what the court is going to do. The court, do you have any children?
No.
Don't have any children until you work on yourself, okay? Court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person. Regular UAs, I want him tested for levels.
Yes, ma'am.
$1,000 fine. That will be probated. Proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits 1 time per month for 3 months. Make sure y'all talk to the mom. 100 hours of community service restitution. I don't know. Does he need a probation? Does he need a life skill course? He's just a young, I know he's an adult, but he's a young child living in his mom's backyard, getting intoxicated like it's Animal House.
And he's working
Yes.
with a skill.
He's a roofer.
I think life skills would be appropriate.
All right. So 100 hours of community service restitution. We're going to do the life skills course. Once that's completed, the community service hours will be deemed satisfied. And there should be no possession of firearms. And we'll do a TAP evaluation out of custody, follow TAP recommendations. If TAP recommends inpatient treatment, start with outpatient treatment. Probation, is there anything else?
No, ma'am, you got it all. Thank you.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Okay. Here's my recommendation to you. There are some movies that are great movies, and they have what I call life lessons in them. You know what movie you should watch since you use profanity against your mom? You should watch the original version of this movie called Imitation of Life. Okay? You watch that, it will most definitely make you appreciate your mom more. Okay? All right, good luck to you.
Thank you, Judge.
You're welcome. Who's next?
Gabriel Martinez, page one down.
Gabriel Martinez. Yes.
Good morning, Judge.
Good morning. Have you all completed your mission?
We did. Successful.
Okay.
Thank you for all your help.
You're welcome. All right. How old are you?
21.
21. Make better decisions in your life. You don't want to be back here. You understand?
Yes, ma'am.
You don't want to be, well, you've been in custody before and you don't want that, right? So make better choices. Okay? Good luck to you.
Thank you, Judge.
You're welcome.
Oh.
Clayton Saunders. All right. And so I want to let you know, your clients appeared with shorts on the Zoom.
Oh, okay.
Yeah.
I'm sorry, Judge.
That's good. All right. So what is happening with this case?
We
Counsel?
submitted our PTD agreement a few days ago, so I expect hopefully in the next week he'll have done his intake and he'll be accepted into the program.
All right, Norma, I need a PTD date.
Can you do August 31st?
All right, Mr. Saunders, you can unmute.
Okay. Yes, ma'am.
So when you appear by Zoom, you have to dress as though you're in court. You understand?
Yes, ma'am. I have jeans on.
Okay, all right, thank you. All right, so August 31st, hopefully you will have completed everything. Make sure that you that you follow through on everything, okay?
So everything has to be completed by August 31st?
That's just your next date, and you can appear by Zoom, all right?
Yes, ma'am.
I'll talk to you. Wait.
Okay.
All right, thank you. Have a great rest of your day.
Thank you, Judge.
Thank you.
Welcome. Kimberly Tarwater. All right, so today is plea deadline date.
We need a jury trial setting, Your Honor.
All right, how long do y'all expect this trial to last? All right, Norma. They need a jury trial date. Can you put this on the 18th of August? All right, August 18th.
Thank you, Judge.
Once you sign the reset form, you will be excused. You too. And then let me make sure I have an acknowledgement of discovery. State, if you can do an acknowledgement of discovery. Thank you. Tommy Armstrong.
Your Honor, he's right outside the courtroom. He's saying he has a new strain of COVID and
we don't want that here.
yes,
And it's a new strain.
that's what he was
Is this alpha or omega? We don't know. All right, so it's set for discovery. Have you received all discovery?
Yeah, Your Honor.
Thank you. And was an offer tender?
There was, Your Honor. We also would like to ask the court if we could get a referral to a Veterans Treatment Court. He's a veteran.
Okay. Norma,
Yes, ma'am.
set this for a plea deadline date. You want to do August 31st?
Yes, ma'am.
All right, and then do a referral to Veterans Treatment Court.
Yes, ma'am.
All right, thank you.
Your Honor.
On page 90 down.
Thank you. Veronica Wicks. And have you all conferred with probation?
We have, Your Honor.
And you're all ready to proceed?
We're ready. The state will have a recommendation.
All right. Court is calling 2025 CR 003243, State versus Veronica Wicks. Could I have parties announced?
Yes, Judge. Brandon Prayer for the state.
Michael J. Sawyer for the defendant.
And are you Ms. Wicks?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Veronica Wicks who was placed on deferred adjudication in this cause number for possession of a controlled substance, penalty group 1 to 4 grams on May 12, 2025 for a term of 5 years? Is that you?
Yes.
State?
Judge, we put some violation of condition number 4, specifically that in Berry County, Texas, the defendant, Veronica Marie Wicks, did then and there fail to report to the supervision officer as directed for the months of April and May 2026, violation of condition number 4.
How do you plead to that? True or not true?
True.
And the state will waive the remaining allegations.
Any objection?
None, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Judge. The proposed agreement is to amend the conditions for Saturday.
All right, so here's my question. When she was first placed on deferred adjudication, I ordered a referral to felony drug court. Was that done?
No.
Probation, do you know if the referral to felony drug court was completed?
Working on that right now, Judge.
And while they review this, is this the proposed agreement you want the court to follow?
We would, Your Honor.
Judge, it does not feel like it was done.
All right. I'm gonna give you a choice. One, I can follow the agreement, but it's gonna be a referral to felony drug court. Do we need an updated TAP evaluation on her or no?
No.
All right, so I can follow your agreement, or I can revoke you and sentence you, and I'll sentence you to 4 years in prison. Which do you prefer?
Oh, the agreement.
All right. Court is finding violation of condition number 4 true. I want the following done in custody. I want a referral to felony drug court. If not accepted, then it's going to be SATA. And upon release, I'm going to want 2 sober support meetings per week. And there's to be no residing in households with children, with minors, and no unsupervised contact with minors. Probation, is there anything else requested?
No, ma'am, we can do all of that.
All right, is there anything else you need from the court to be successful?
Your Honor, my client asked me to request the court, can she get some kind of job counseling to help her out?
All right, and if we could do a job skills course, please. Okay.
Thank you, Your Honor, that's all I have.
Good luck to you. Here's the thing, you got to report.
Yes, ma'am.
And if you think that you're going to use, that's when you need to call probation and let them know so that they can redirect you, or either when you go to sober support meetings, get a sponsor and call them up and say, hey, I'm thinking about using. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
You're welcome.
Thank you, Your Honor. I'm out of excuse.
Yes.
Have a good day.
Well, thank you. Christina Moreno. All right. So there was an issue with this case because of Axion. So what's going on?
That was resolved.
Okay.
Now I've been given offers. I've talked to my client. I've shown her this video, the one that really matters. And my client does not want to take an offer.
Okay.
And she wants a trial. So we need a trial set.
All right, Norma, jury trial date. All right, August 18th, and you need to make sure you're on time. Do you understand? All right, once you sign the reset form, you will be excused. And if you all could state on Christine Marino, if I could have an acknowledgement of discovery, please. Thank you. You're welcome. George Garza. Hello. Oh, and we have another municipal court thing for your client.
Municipal court.
Yeah. So anyway, municipal court, they are not accepting any of these warrants. So, you have some people who are in custody. And I'm like, oh, this person has a warrant. And when it's from municipal court or JP, they're like, we're not coming to pick them up. So he has a failure to maintain financial responsibility insurance. So you better check on that.
Yes, sir.
All right. Otherwise, I don't know, the police may still pick you up. Okay, now that that is out of the way. Where are we on this case? I know last time you were unable to view the discovery.
Essentially get one final discovery, so right, I want the chance to not give to our own style, and I'm serving it. Contractual wish.
All right. Norma, 30-day reset. All right, August 30, yes. All right, the state is, okay. State is saying they need 45 days. Are you okay with 45 days?
That's fine.
What date?
1 second.
September.
Yeah, September 14th.
All right, September 14th. Thank you for dressing appropriately for court.
And what is that for, Judge?
It's, do y'all want to put that as a plea deadline date?
Yeah, that's fine.
All right, it's a plea deadline date.
Loretta Holmes, page 10, feet out.
Larietta Holmes.
Judge, we're on just a probation, status, compliance, yes.
Probation,
Yes, ma'am.
on this case, how are things going?
From what we can tell, excuse me.
Have you been doing your sober support meetings? 1 per week?
Yes. They do have some sober support meetings that have been scanned in. I did not look them over. Her last 3 UAs have been negative. So from May of 26, June of 26, July of 26 have all been negative. She completed her Bear outpatient program May 11th of this year. This recommend the client remain compliant with the conditions of community supervision by making regular payments towards supervision fees and restitution, completing remaining community service hours, providing verification of compliance at each reporting appointment. The client should continue working towards satisfying all court-ordered financial obligations and community service recommendations.
All right. So, Norma,
Yes, ma'am.
what we're gonna do on this, we will do a final status in September, and if everything is fine, then maybe there'll be no more need for a status.
Yes, sir.
Is there anything else that she needs?
Yes, actually, there was another concern that the probation officer put on here that they had. I guess at the court hearing, they recommended an 18-month extension because ISP supervision was ordered. She is not eligible for ISP supervision because she's got less than a year left on her probation.
All right.
So,
all right, we'll address that at the next status.
Okay.
Okay. All right, Norma, September date.
14th.
All right, September 14th for status.
Okay.
And then depending on what happens or how she's doing, we may extend or not.
Okay.
All right, thank you so much. Thank you for the update.
Thank you. No problem.
All right, Joseph Walker. All right, you have 2 pending cases from the precinct court. Failure to use a seatbelt and no driver's license. So you need to take care of that. Do you understand?
Yes, I made a payment on one of.
Oh, no. I'm just saying it shows open. So I'm just letting you know in case you don't know. All right, today is plea deadline date.
I received an offer, Judge. However, Ms. Espinoza and I have an offer, but there's some things that I pointed out in the videos that she's gonna review. So I'm hoping with that, maybe we can get a different offer.
All right, Norma, final plea deadline date, 3 weeks.
August 20th.
All right, August 20th, and you need to make sure you're on time for court. Court starts at 9 a.m. Do you understand? All right, you can have a seat. Once you sign the reset form, you will be excused. Thank you. All right, so what is happening with Javier Garcia? Oh, Javier Garcia, come forward. All right, you need to make sure you're on time. Court starts at 9. You understand?
Yes, ma'am. Sorry about that.
All right, so what is happening on this case with the phone dump and everything else?
So we conferred with the state prior to today. We hadn't had an offer. It was our first offer. We discussed that with him, but I think we still have some discovery issues. So we're requesting another pretrial setting until we can make sure we have all of our discovery.
All right, what is the outstanding discovery?
This Judge, I know having DPS detective bring me an external, I just need to double check that it was uploaded to Axon. I know we uploaded a significant amount last setting. I just need to double check that, so I can try.
All right, so your final discovery setting, Ms. Ferguson, if I can have a 30-day reset? All right, August 31st. Make sure you're on time.
Yes, ma'am. Sorry about that.
Sure. Just have a seat. Once you sign the reset form, you'll be excused. All right, Javier Olvera.
We're ready, Judge.
Robert, on this case, the violation, we are going on the violation.
Yes, ma'am. Yeah, they're gonna dump the other case.
Okay. And there's an application,
Yes, ma'am. It's a recommendation.
and as soon as they're ready over there, I'll take you up. Court is calling 2026 CR 008220, State versus Javier Olvera. Can I have parties announced?
Defendant for the state of Texas.
Robert Mauer for defendant.
And are you Mr. Olvera?
Yes.
Probation, this is an application.
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We did.
Court will find that the state is in compliance with discovery. Mr. Olvera, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading?
We do.
State, are you proceeding as presented?
Yes, we are, Your Honor.
Mr. Olvera, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with violation of bond or protective order more than two times or more within 12 months. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Ms. Olvera, Mr. Olvera, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, or re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Before we move on to the plea bargain page. No, you did not. I have a question. So there's a no harmful or injurious contact with the complainant. So number one, is there a protective order in place?
I'm a protective order with bond conditions.
It was bond conditions. The complainant had apparently done an A and P.
Mhm.
There's no contact. The violation was them living together. So we just want to make sure that there's no further violations.
All right, so here's my question. Have you spoken to her? Does she want to live with him?
Yes, ma'am.
All right, so
I think
this
she's
is-
avoiding the contact because she wants the charges dropped.
All right, so here's the thing. This no harmful or injurious contact, I know that's a part of your plea bargain agreement. I don't follow that when it's assaultive behavior or if there's some type of violation until the complainant, lets me know that they're fine with this. So if this is going to be a deal breaker for your plea bargain agreement.
Well, I think the problem is, Judge, it's going to set him up for automatic failure because I think the reason she's not contacting the DA's office is she wants the charge dropped.
What do you want to see if somebody wants to talk to her and see if she wants to zoom in? If she zooms in and says that she just wants a no harmful or injurious contact, then I'm inclined to follow that.
Judge, I can try calling her. I can tell you, I'm out tomorrow and I can't be back this afternoon, so I have to try to do it maybe Monday.
Okay, if y'all want to do it Monday, or if y'all want to see if you can get in touch with her now to zoom in.
I'll try calling her.
All right, just have a seat. Court is calling 2025 CR 011882, State versus Jeremy Bass. Can I have parties announced?
To the state.
Greg Gamer for Mr. Bass.
And are you Mr. Bass?
Yes, ma'am.
Counsel, have you received all discovery that you reviewed with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Bass, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
It's good.
Mr. Bass, did you review the court admonishments with your attorney? Did you understand it?
Yes, I did.
All right, you're charged with theft of property, $2,500 to $30,000. As a state jail felony, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution to Total Quality Logistics in the amount of $16,000.10. The court will note for the record that the court has been presented with proof of payment of restitution of $8,000.
That's correct, Judge.
And I guess this will be given to Timothy
Philberg, yes, Judge.
Philberg, Thilberg. And I'm sorry, it's $16,010.10. And of that amount, he's paid $8,000. Did you understand that to be the plea?
Yes, I did.
State defense?
Yes, Judge.
We did, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years, a TAP evaluation, 140 hours of community service restitution, anti-theft course, no contact with Total Quality Logistics, Timothy Philberg, Thilberg, and Matthew Moranta. Yes, Moronta. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State's Exhibit 1 and all attachments.
No objections, Judge.
All right, did you review the waiver and stipulations with your attorney? Did you understand it? State you may be excused and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. After reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Your Honor, my client is aware, obviously, of what he done, and he has taken means to rectify that. And we just ask you to follow the plea bargain.
All right. How much are you able to pay towards the remaining restitution per month?
Every month going forward?
Yes. And don't tell me what you think I want to hear. Tell me what you're able to pay.
Going forward until it's paid off, I would say 150. More than likely more, but just to be safe this time.
Right. So he's to pay, it's 5 years deferred adjudication. He's to pay $150 per month towards the remaining restitution of $8,010.10 to Total Quality Logistics. And that's Timothy Thielberg. There's to be no contact with Timothy Thielberg outside of paying restitution. And there's to be no contact with Matthew Maranta.
Is there anything?
Or Total Quality Logistics. So what do you do for a living now?
Right now, I rent out my vehicle on Turo. I also have these inflatables that we rent out every weekend and throughout the week. I also detail cars. It kind of brings my income right now to about $3 to $4K a month.
Okay.
But I will be starting a logistics company pretty soon in September, October, and that'll be more like my career.
All right, there's to be no employment as a home health care provider with minors. He's to provide proof of employment within 40 days. There's 140 hours community service restitution. Do you have children?
Yes, I do.
What are their ages?
I have 3. One is 15, one is 11, and one is turning 3 in September.
All right. 150 hours community service restitution. I'm already in parenting classes. Once that's completed, 70 hours will be deemed satisfied. The remaining 70 hours will be deemed satisfied once he's completed the anti-theft course.
Thank you, Judge.
There's to be regular reporting by Zoom or in person, regular UAs, field visits 1 time per month for 3 months. Probation, do you want no firearm possession?
Please, and, the theft class, you want to level 2?
Yes. And there's to be no firearm possession.
Your Honor, if his wife is in possession of a gun, how does that extend?
Oh, you all will need to come back and ask me to change my orders.
Yes, Your Honor.
All right. Is there anything else you need from the court to be successful?
No, ma'am. Thank you.
And you're welcome. There's a $0 fine. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand that?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. All right, good luck to you. Stop making bad choices, okay?
Yes, ma'am.
All right, thank you. Joseph Gonzalez.
That's working on court.
All right, so what are we here for?
Judge, we're here for
For
a
restitution?
hearing.
Yes.
Unfortunately, Judge, we've had some problem with making contact with our complaining witness after the plea. I've spoken with opposing counsel. We're okay with doing a short recess next week. I should have something back by the end of the day, and then we can meet next week via Zoom, if the court will allow.
Your Honor, I have no problem being here. I just asked that if my client be allowed to join via Zoom, that would be appreciated. Beautiful.
All right, Norm, I need a reset date for restitution. They're saying next week, give them 2 weeks.
I can do August 13th.
All right, August 13th, and the defendant may appear by Zoom. You're welcome. And counsel, if you'll just let your client know when you're present so they won't be on Zoom for a long time.
Yes, ma'am. I will coordinate, and he was on time, so I feel better.
All right, thank you. Once you sign the reset form, you're excused. Robert Maurer,
We're good. Rick's gonna enter her number. He talked to her. Hopefully the dialing 1-900 numbers on my phone.
Okay, so Rick has already talked to her?
Yes.
Okay,
I talked with her, she said she wants no contact order lifted, she wants it to now from jurisdiction.
all right, let's come forward.
Love Bloom.
All right, we're back on the record in 2026 CR 008220, State versus Javier Olvera. Can I have parties re-announced for the record?
Rick Painter for Cedar, Texas.
Robert Mao for defendant.
All right, and you, Mr. Olvera?
Yes.
Did you review the plea bargain page with your attorney? Did you understand it? All right, so according to the plea, punishment is to be assessed at 6 years in prison, $1,500 fine. State is recommending community supervision. There's to be no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, sir.
State defense?
That is a plea, Judge.
Yes, Your Honor.
All right, and state, with regards to this no harmful or injurious contact, did you have a chance to speak with the complainant?
I did just convince her, Your Honor. I asked her a series of questions, and after a series of questions, she indicates that he does not want to have more.
All right, and is that correct, counsel?
That's correct.
And counsel, I believe you stated earlier that she had also filed an affidavit of non-prosecution.
Yeah, I don't have a copy of it. She might have provided it to SAPD, but I know she had indicated that she wanted to drop the charges. I think that's why she wasn't responding initially.
Okay. All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years, 200 hours community service restitution, anger management, TAP evaluation, follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
No objections.
Okay. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And state, you may be excused.
Thank you, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, I just asked the court to grant his application. He's been incarcerated for 5 months on and off bond. So I think he's ready to get on with his life.
How old are you?
56, ma'am.
All right. Here's the thing. You're going to be in probation out of this court. She is saying that she wants you, I guess, to move back in with her. You know better than I do what your relationship is like.
Yes.
Maybe this is a relationship where you all shouldn't be together. You understand?
Yes, ma'am.
Because if the court receives a phone call that you violated the court's orders, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right. When's the last time you had employment?
Oh, I worked all my life, 25 years.
He does concrete work, Judge. He's just been unemployed since he got incarcerated.
All right. Are any children in that household?
No.
All right. The court is finding you guilty. The court will sentence you to 6 years in prison, suspended and probated for 6 years, regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody, follow recommendations. However, if TAP recommends inpatient treatment, we'll start with outpatient treatment. There's a $1,500 fine that will be probated. There's to be no harmful or injurious contact with Marella, Mariela, Barrera. Field visits 1 time per month for 3 months. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. No residing in households with minors. 200 hours of community service restitution. The court is going to order anger management. Once anger management is completed, the community service hours were deemed satisfied. No possession of firearms. This is a conviction, it's felony conviction. You're not allowed to own any firearms. Do you understand? Okay. Probation, is there anything else?
No, ma'am.
Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, good luck to you. Make better decisions.
Thank you, Judge.
And do you have the other?
No, it's.
Print out.
I'll get that.
All right. All right, Azula Ziermel. All right, good morning.
Morning.
So you just repeat everything that I'm saying. All right, so what is happening today?
Judge, we'd ask for a reset so I can further investigate some of the things I've learned today.
All right, do you have any questions?
No.
And how long is this going to take?
Because of the language issue, probably at least 45 days.
All right, so did you tender an offer?
Yes, Your Honor.
Oh, if you could speak up so I can hear. I love different languages. And so, let me hear is it Persian?
It's Pashto.
Oh, yeah, let me hear the language. All right, so how long would you all expect this jury trial to last if it's a trial? Because he has two cases.
Correct. Obviously, the assault case is the more pressing case. It'd probably take a whole week.
All right, and all right, Norma,
Yes, ma'am.
and I hope you'll be available. If you will not be available, let me know. Norma, set this for a jury trial and a plea deadline date in 60 days.
Thank you, Judge.
All right, are you available?
I'll be available.
September 28th?
Yeah, I'll be available.
All right, so they're going to give a reset form just so you'll have it. And so we'll need you for that entire week if they decide to go to trial. All right, thank you so much.
So much.
Thank you, Judge.
You're welcome. Oh, and sir, if next time, I'm sure if you need the headphones for him, just let us know. And I know that the interpreter upstairs will be more than willing to provide that for you.
I'm familiar with it because I had a last file and we used that. It helped a lot.
Okay.
Yeah. All right. Thank you so much.
You're welcome. Thank you. Who's next?
It is Lacy Wheat, page 3, one down.
Lacy Wheat.
Okay.
And Norma, you have the interpreter's number?
The one that has it is Thomas is the one that's in contact with me.
Okay, if you'll make sure they know the next.
Out by today.
All right, thank you.
Different.
Good morning. How are you doing today? What's the tears?
We're working towards resolving this ordeal for her, Judge. It's been a lot of stress on her.
All right, so where are we on resolving this?
Still outstanding discovery, no CPS as of this date. Last court, we did bring that to light for the court so we can have that. And I was just informed by the state today that they do not have that in their possession. So that's
right. The CPS matters. Is that from Bexar County? Can somebody pick up and call the prosecutor on the CPS side and just say, hey?
That's what I was kind of suggesting. I did speak with. Go ahead, Judge.
No, because if there's a CPS matter that's ongoing, the prosecutors over there will have the CPS records.
And Your Honor, I believe at this stage, it is delaying the proceedings. I know the DA's office has a number of investigators, paralegals, as well as attorneys, and the fact that we do not have that at this date is concerning for me and my client in deprivation of her due process rights, Judge. We did file a writ of habeas corpus pursuant to 17.151 due to this delay. She is in custody and she has been in custody on this alleged offense.
Right, let's do this. let's recall this. We're going to recall this in 2 weeks. CPS records, they need to have them. If they don't have them, then we can take up whatever matters you wish to take up, and the court will hear whatever motions you have.
Yes, Your Honor.
All right, and the reason why I'm giving the extra time is because we were here June 16th about the CPS records. And I understand sometimes CPS records, if they're not ordered when whomever was in intake doing this, there's an issue. So we're going to come back in 2 weeks to get that done. August 13th. And then what is her bond?
Her bond is set at $150,000, Your Honor, and we did file a motion to reduce that bond. And my client is asking that the court consider reducing the bond. I know typically in these type of cases, 150,000 is an extreme amount.
Are y'all ready to proceed on the motion to reduce bond?
We're going to stand down because that bond was not, I'm sure there's that bond.
Well, I mean, let's not.
I would say the grand jury doesn't have a lot of insight as to how legal matters work. They're lay people, members of the community. So,
well, let's not stand silent. I'll still need some evidence. So it's noon. Are you able to come back this afternoon?
Yes, Your Honor.
All right. So we're going to come back on Miss Lacy this afternoon at 1:30 to hear her matters.
Thank you, Your Honor. Feel free to hear that. Thank you.
Keyshawn Merritt. And is there an application?
Yes, ma'am.
Yeah. And is it opposed?
Yes.
All right. I need a PSI date, please.
Yes, ma'am. Give me 1 second, Judge.
Hello. Is there going to be a need for a tap?
We'll take one.
All right. Probation.
Yes, ma'am.
It's going to be a PSI and tap evaluation on Keyshawn Merritt.
Thank you.
And it's going to be set for September 14th. And is there a need for any mental health evaluation?
We'll take one as well.
All right. And it's going to be a MIC evaluation as well.
Yes, ma'am.
Court is calling 2025 CR 015747C and 2025 CR 015750B, State versus Keyshawn Merritt. Can I have parties announced?
Let me grab behalf of Mr. Meredith to my right.
And are you Mr. Merritt?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
To the best of my knowledge, and yes.
Court will find that the state is in compliance with discovery. Mr. Merritt, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment in each of these cause numbers with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, please.
State, are you proceeding on the indictments as presented in each cause number?
Yes, sir.
Mr. Merritt, did you review the court admonishments in each cause number?
Yes, ma'am.
In the cause number ending in the letter B, you're charged with robbery. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that case, the court could find you guilty. If a motion to revoke were filed, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. In the cause number ending in C, in counts 1, 2, and 3, you're charged with aggravated robbery. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication, will revoke, the court could find you guilty and sentence you to life in prison in counts 1, 2, and 3, and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause number? Counsel, has your client been Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Merritt, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas? Anyone promised you anything other than the plea? Satisfied with the way you've been represented? If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it? All right, according to your plea, the cases are to run concurrently. The state is taking in consideration 2026 CC 006-033, 2026 CC 12013. The state is opposed to your application. And of course, counts 1, 2, and 3 will run concurrently. There's a cap of 15 years in each case in the prison, $2,000 fine. There's an affirmative finding of deadly weapon in the cause number ending in C. Did you understand that to be your plea in each of these cause numbers?
Yes, ma'am.
All right, state defense. In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Then, in the cause number ending in the letter B, how do you plead? Guilty, not guilty, or no contest? And in cause number ending in C, how do you plead to count 1?
No contest.
To count 2?
No contest.
To count 3?
No contest.
State any evidence to support the defendant's plea.
Stafford states 1 in attack.
No, Judge.
All right, state you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you in each count guilty and in each cause number guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. We will come back on September 14th. At that time, I'll base my decision on whatever evidence is presented. With regards to the PSI, TAP evaluation, and MIC evaluation, probation will probably see you more than one time. Just make sure you speak to them. Counsel, if there's an issue with the jail, as far as maybe there's a different rotation or something and they don't get a chance to see him, just let the court know and we'll make sure it happens.
Thank you, Judge.
All right, good luck to you. You're welcome. Thank you. Carlos Tiente. All right, why were you late?
Oh, I was at work, man. And I didn't get a notice till this morning, so.
I mean, you had court on June 16th.
Your Honor, we did speak with his wife yesterday. I think there was some confusion about whether it was today or tomorrow, but I can tell you that as soon as we got a hold of him, I mean, he rushed over.
Well, I mean, last time, did he sign a reset form?
Yes, Your Honor. And Ray did speak to him about that.
Yes. So next time you need to be on time. You understand? All right. So what's happening with this case?
Yes, Your Honor. So this case, as well as co-defendant Robert Ustrio, Vasquez, those both came to our court, were transferred to this court fairly recently. Lois Christian is on the Ustrio case. I'm giving them all of the discovery. I'm going to make sure the discovery on their case and this case are complete and complete by each other. The other thing I need to do on this case is, as soon as the defendant gave a statement that has not yet been translated. So I'm going to get that translated. They'll need 40 days, 45 days to comply with the law, as well as the time for them to object anyway. Confusion on it. So I would ask this court for 60 days. If this court's willing.
Norma, recall this for 45 days for discovery.
Sure.
September 14th.
All right, September 14th.
Yes, ma'am.
Once you sign the reset form, you'll be excused.
Thank you, Your Honor. I'm sorry about that.
No problem. Thank you. Mickey Vasquez.
How you doing, Your Honor?
Oh, I'm doing okay.
Judge, on Mickey Vasquez, there's some additional information that it's on the file that I have not received. I think it will turn this matter in a resolution of a plea bargain. However, I need to review it. I may have a 2-week deadline, either for trial or plea or.
All right, Norma, set this August 10th for jury trial and a plea deadline date.
Thank you, Your Honor.
All right, once you sign the reset form, you're excused.
Yes, sir. I have one other matter, Your Honor.
Who's next? I'll just have a seat that bring the form to you.
Pedro on page 4 on the bottom.
Pedro Lara, Your Honor.
Pedro Lara.
Your Honor, at the last court setting, the court signed an order for the state to produce medical.
Yes.
And to date, they haven't, but they're still within
All right, state.
time frame.
Where are we on the blood discovery on this?
Has he come back yet? It's circled back to the lab yesterday and haven't heard back, but I'll ask the lady at DPS again to provide an update. I know they had about a 60-day lead time last I found.
All right, Norma, recall this for August 31st.
Yes.
Thank you, Your Honor.
Thank you. You're welcome.
For discovery, Judge?
Yes, and an offer is due at that time. All right, court is calling 2026 CR 001840-02, State versus Lacy Wheat. Can I have parties announced?
Retained for the state of Texas.
Renee Munoz on behalf of Ms. Wheat.
And are you Ms. Wheat? All right. Defense has filed a motion requesting a bond reduction. State, have you had a chance to review the motion? All right. State, are you objecting to the reduction?
State will remains, just add for purpose of the record that I looked into the reasons why the bond, was set aside as it was, it was not a recommendation to the state. It was just a jury after they true build the case, do that number.
Right. So what I can tell parties is there needs to be some form of evidence presented to me. So is anybody going to present any evidence?
If I may call my client, Your Honor, for the purposes of the bond motion.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Lacy Charlene Wheat.
All right. You may proceed.
Thank you, Your Honor. Hi, Ms. Wheat. So in terms of your residency here in Bexar County, how long have you resided here?
We moved here when I was 9.
Okay. And you are how old at this time?
64.
Okay. So around 45 years or so, you've been residing here in Bexar County. Have you been active in the church at all?
Yes, I go to Grace Community Church. It's been almost 20 years, the same church.
You've been active within that church for 20 years, you said?
Yes.
Okay. Aside from this arrest in relation to this charge, when was the last time you were arrested?
Maybe in 1990, something like that, early 90s.
Okay. And do you remember what that was for?
I think I was driving with a suspended license, but I didn't realize it was suspended because it had been from no insurance for years.
And that's all the way dating back to the 90s, correct? Okay. And in terms of the $150,000 bond currently set, is that too much for your family to make?
That's way beyond anything.
It's way beyond anything you said. Okay. And in terms of your assets, do you own any assets?
A 2000 Honda Civic.
Okay. How many miles does it have on it?
265,000.
Okay, 265,000 miles on that. Okay. Would you be surprised to learn it like the Kelly Blue Book estimate was around $300 to $700 for that? Would you be surprised to learn that?
It's worth more than that to me.
Sentimental value. Okay. Monetarily.
Transportation.
Yeah, monetarily different story, right? Okay. And essentially you haven't worked actively since how long?
Since about 2012, 2013, I'm on disability.
Okay. And you're on disability, and how much disability do you get per month?
I think it's like 1,123 or 25.
Okay, and that's used for your day-to-day, your living expenses as well, right?
Yes.
Okay. No other further questions, Judge?
Yes. Ms. Wheat, what's your questions for you now? You said you're not working and you're supporting yourself on disability. What kind of support system do you have around this?
What kind of
Support system do you have? Yes, ma'am.
The property I live on is right next door to where my son lives.
Okay.
Um,
Do you own the property that you live on?
my son does.
Your son.
I'm
And other than your son, is there anyone else in your life as far as your support system goes?
he's my boyfriend when he's around. He works and stuff.
So your son in what? Does your son work?
Oh, yes.
What do you do for a living?
He works for fire suppression system company.
Okay.
And then his wife also works.
Do you have an idea about how much he earns at that job?
I have no idea. I don't ask.
I would assume he earns enough though to buy the property, right?
Oh, we purchased the property before when he was younger.
Oh, understand. Okay.
My ex and I.
Understood. And what about your boyfriend? Does he work?
He works.
What does he do for a living?
He works at a barbecue place in Cibolo.
Barbecue place. Is he like a server or something, or is he in a kitchen?
Yeah.
That's nice. All right. So other than you getting your disability, would you rely on either your son or your boyfriend for any type of financial support?
I wouldn't rely on him. No, I wouldn't want to.
Do you need them though occasionally, or no?
Occasionally.
Or
emergencies or something like that. I don't want to do that.
okay. And my last question is: you understand that part of your bond condition is that you would not have any contact with victims, right? You understand
With
that? Victim of the case?
Oh, definitely. They don't live there anymore.
No contact between you as a legal party.
Mhm.
Okay. That's what you're trying.
No further questions or be direct, Judge.
All right, any other witnesses?
No further witnesses from the defense.
I'm just
All right, so no other evidence from either party.
If the state wanted to put forth her NCSC, TCSC information, I wouldn't have any objection to that. Last time she was arrested was in the 90s, but if the state wanted to confirm that. If the court would like to see that.
I cannot mark it as an exhibit, but I can tender on for the information. In 1984, the defendant was arrested for a DWI, convicted and given 1 year of probation. 1997, the driving license suspended, as she alluded to earlier. Looks like 2 of those during that same year. No, it's that earlier, but in 1996, of course, she had another driving license invalid. Then the third one, 1997, driving license invalid. Other than that, Your Honor, that is the extent of the defendant's criminal.
But obviously in considering the
And while the state is downloading that, what bond amount are you requesting, counsel?
Your Honor, respectfully requesting the amount of $25,000. My client does not have an abundance of money. She has not worked in some time. She just basically gets disability just to sustain herself on. Further, she has deep ties to the community. It's not a flight risk. She's been here in the community for over 45 years and has participated in the church program for over 20 years based upon her testimony here, Judge. She's not a flight risk. If she is released, she will attend all court hearings as scheduled and abide by all bond conditions, Judge. She's been in custody since June 13th on this. to basically living her life. And then she got accused of this. The indictment triggered the warrant, and she's been in custody on this, Judge.
We are deep into this bond reduction hearing, and the stakes could not be higher. Lacy Wheat is sitting on a $150,000 bond she cannot afford, and her defense attorney is painting a picture of a woman with deep community ties, a disability, and zero flight risk. But here is the twist. The state is pushing back, citing her criminal history from the 90s. The judge is about to make a decision that could change Lacy's life. Will she get a fair break or stay locked up? Let's see how this plays out.
All right, and does she have any prior mental health issues?
She does have mental health issues, Judge. That's why she gets the disability.
I'm also severely anemic. I was in the hospital for 9 days. I don't know.
No. So with regards to the mental health issues, are you receiving SSI based upon that?
Yes.
All right, what's the mental health? What is your diagnosis?
I have severe depression, PTSD, ADHD, OCD, severe anxiety. I've had a lot of head injuries.
All right. And has there been any past drug use?
Very, very long time ago.
And what would that be?
Marijuana and occasional meth. Ever shooting.
As far as the bond request, you would make sure the allegations of this a second degree felony and life sentence.
I'm sorry, what are you asking for? Okay. All right. And defense, I believe you said you had no objections to state's exhibit?
No objection for purposes of this hearing, Judge.
All right. For purposes of this hearing, only state's exhibit number 1 is admitted into evidence and the court will review it. And also, could you pass me this? The letter, no, that was with the other court reporter. All right. After hearing both arguments, this is what the court will do. The court is going to grant the motion to reduce bond. The bond will be set at $65,000. There's to be no contact with the complainant. I don't know how that's really going to be accomplished. I mean, because according to the stipulations that I received, it says that she lives in the house behind.
They moved, Judge. Yeah.
They were going to be evicted anyway, so that's fine.
Yeah, they're not no longer in the vicinity.
So no contact with the complainant.
Anyone else with a question? Yes,
I mean, is there any danger between her and the complainant?
No, there have been no other allegations of any kind of instances of violence directed or threats towards a complaining witness, coupled with she doesn't have violent criminal history whatsoever, and she's been in the community, Judge, without any issues since the 80s. I don't believe that GPS would be a reasonable condition.
All right, I'm not gonna ask for GPS. I'll do UAs, waive the fees. There's to be a referral to Center for Healthcare Services. All right, is there anything else?
Nothing further from the defense, Judge.
All right. And Norm, if you give her a reset form, because this case is being reset for August 13th.
Yes, Judge, will do. I'll execute that. She will as well, in case she's released, Judge. And then after that portion, may I be excused?
Yes.
Thank you.
All right, Max Henry Perez.
She's not here. Counsel's present, Judge, on Zoom.
She's on Zoom.
No, I'm on, he's in the courtroom. I'm on Zoom.
All right. Court is calling 2026 CR 007183 and 2026 CR 007182, State versus Max Perez. Can I have parties announced?
For the state. Lindsay Shaw for Mr. Perez.
And are you Mr. Perez?
Ma'am.
All right. Any objection to your attorney appearing by Zoom?
No, ma'am.
State, any objections? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Pettis, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the cause number ending in 8-2, are you proceeding on the indictment as presented? And in the cause number ending in 8-3, are you proceeding on the indictment as presented?
No, Judge, state waives and abandons count 1 and proceeding solely on count.
Any objection?
No, Your Honor, and I'm apologize for my camera. I don't know why it keeps turning off.
Oh, okay. It happens.
Yeah.
But you're fine.
Okay.
All
thank
right.
you.
Mr. Pettis, in each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. In the cause number ending in 8-3, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. In the cause ending in 8-2, you're charged with an unlawful possession of a firearm by a felon. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, I do not have to follow your plea. If I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea and each cause number, punishment is to be assessed at 3 years in the prison. There are no applications. The cases will run concurrently. There's a $600 fine in each cause number. And in the cause number ending in 3, the state is proceeding on count 2 only. Did you understand that to be your plea?
Yes, ma'am.
State and defense, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motion?
No, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State offer State's Exhibit 1 in knowledge.
And there it is, the final verdict. Judge Boyd is looking at Max Pettis, a 42-year-old man with felony convictions, and she is not holding back. She tells him straight up, "You are 42. Maybe you will live to 84. Do you want to spend half your life in prison?" That is a gut punch. She is giving him a chance with 3 years, but she is also warning him if he does not change, he will be back. That is the reality of the system. Some judges just sign papers. Judge Boyd? She is trying to save lives. Huge respect for that.
No, no objection.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. In each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, Your Honor, I believe he is worthy of the plea bargain. We ask the court follow it.
And cause number 2026 CR 007183. As previously stated, the court is finding you guilty. Court will sentence you in count 2 to 3 years in the prison. There's a $600 fine. Time and money will run concurrently. This will run concurrent with 2026 CR 007182. Court will give you credit for any time served. And cause number 2026 CR 007182. Court will sentence you to 3 years in prison. Credit for any time served, $600 fine. Time and money will run concurrently. This will run concurrent with 2026 CR 007183. There's to be no unsupervised contact with minors and no residing in households with minors. In each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. These are felony convictions. You're not allowed to own or possess any weapon or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Ma'am.
How old are you?
42.
And you got to make a decision. Do you want to? You're so close to being in the twilight of your life. You know why I say that? Because unless you're planning on living to be 120 or whatever it may be, that would be great if we have all our faculties and we can still be independent. But you're 42, right? Maybe you'll live to be 84. But do you want to spend that time living at a prison? So you got to change. If you don't change, that's what's going to end up happening. You understand?
Yes, ma'am.
All right, good luck to you. Make better decisions.
Thank you, ma'am.
All right, good luck.
Sweet.
Good luck, Max. Thank you, Judge.
You're welcome. Have a good one. Tatum. Mayan Tatum. I think I pronounced the first name correctly this time. We shall see. Oh, Mr. Cox.
Yes, ma'am.
How's it going?
It's all right, Judge. This is just first sitting case.
Okay.
Until 22 weeks ago. For the ink is still.
2 weeks ago. And
The ink
still
is still, ink is still wet on the point. But I came anyway, and I've conferred. So we just need, I need some time to go over discovery on time.
All right. Recall this in 30 days for discovery. All right.
31st.
Thank you.
That'll work. Thank you, Judge.
You're welcome. James Hester. See. Jesse James Noel Hester. Probation, this is an application for deferred. The court is calling 2026 CR 003517 State versus Jesse James Noel Hester. Could I have parties announced?
Thank you, Mr. Steve. Pleasure now for the defense.
And are you Mr. Hester?
Yes, ma'am.
Counsel, have you received all discovery that you review with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Hester, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Judge.
State proceeding as presented?
Judge, you can proceed on count 1, waiving count 2.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In count 1, you're charged with possession with intent to deliver 4 to 200 grams. Penalty 1, that's a first-degree felony. Range of punishment is 5 to 99 years or life in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to life in prison and up to a $10,000 fine. If you have a plea with the state, I do not have to follow your plea. If I don't follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Hessner, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Absolutely.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 8 years in prison. State is opposed to your application. This is run concurrent with 2026 CC 008057. Did you understand that to be your plea?
Yes, ma'am.
State defense?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Judge.
Then at count one, how do you plea? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, you say exhibit number 1, including all attachments.
Except for the modification I made to reflect the correct plea, we have no objections.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. How old are you?
I'm 19.
Does he have criminal history?
Not that I saw, Judge.
All right. So here are your choices. 1, defense, if you want to waive PSI, you can waive PSI. I'll grant his application for deferred adjudication. If you are given a motion to revoke, you're looking at potentially life in prison.
Yes, ma'am.
And what is with the bunny tattoo?
I was younger. I was stupid. I was bad on drugs.
Well, the bunny tattoo usually means more than being stupid, as you say. And I will put you on GPS.
I'm fine with
And
that.
people will be coming to your house on a regular basis. Do you live in Bexar County?
No, I live in Medina County.
We don't feel this is outside of the county, Judge.
Well, counsel, you have to find out information through probation about Medina County, because 1, I'm going to want him on GPS if I were to grant his application. And Medina County, there's probation there, a probation officer there. You have to make sure that Medina County is willing to do field visits, because he needs field visits. And I don't feel that the community will be protected if field visits are not done with him. And who lives in this household with you?
My mom, my dad, my little brother, and my little sister.
And how old are they?
My mom and dad are both 28.
No. I'm talking about the children.
My little brother is, I think, 16, and my little sister is 11.
Yes, so that's what I'm gonna need. So when do you think you'll have that information for me, counsel?
I have no idea, Judge. Give me 2 weeks, figure that out.
Okay. And if you're drug tested today, what would the results be?
All negative.
Okay. All right, Norma, recall this in 3 weeks. Are you waiving PSI, counsel?
Yes, Judge.
I'll recall in 3.
August 20th.
Oh, August 20th.
Okay.
I'm not gonna be here.
Okay. Want it the week before, or do you want it the week after?
Do you want it the week of the 10th council or the week of the 24th?
I prefer the week of the 24th, Judge.
All right, put it down for August 24th. All right, thank you.
Thank you, ma'am. Appreciate it.
Okay. Yes, once he signs the reset form.
All right. So
Probation will just be back on August 24th. The defense has agreed to waive PSI. Milton James Franklin. All right, counsel, what is happening?
Good afternoon, Judge. I am his second attorney. I received an offer today.
Okay.
This is my first official setting. What he'd like to do is come by the office, talk more about the offer, and go over some discovery. So formally, we're asking for a reset and a date to announce our decision.
All right, Norma, recall this for August 19th for jury trial. Yes, jury trial and plea deadline date. It's Milton Franklin. 19th.
Judge, would you consider August 26th? I'm out of town on the 19th, 20th, and 21st.
All right, we can do it on August 17th.
Okay.
All right, August 17th, Norma.
Yeah.
Thank you, Judge.
You're welcome.